Good morning, everyone. Good morning, Instagram, Facebook, YouTube. I'm just going to wait for you guys to tune in. Good morning. Good morning. If this is your first time, definitely comment. Let me know it's your first time tuning in. Let me know where you're tuning in from. Good morning, Hayati Omen. Good morning, Miss Attitude. Good morning, Timu Chick. Good morning, Briefed. Briefed says, I have a question. Go ahead, ask your question. I'm Kojer from New Jersey. This is your first time. Well, welcome. Good morning, Vastav Patel from Jamaica. April, good morning. Okay, let me introduce myself. My name is Aisha Chidole, and I'm an immigration lawyer. So I represent clients all over the U.S. with their family immigration and humanitarian-based immigration cases. We take cases in all 50 states internationally, as long as you are looking to immigrate to the United States. You can schedule a consultation by calling 407-995-6567. You can also send a WhatsApp to 404-333-8751. Let's just jump right into the questions. For those of you tuning in for the first time, really, these lives are, for me to just kind of answer some frequently asked questions about immigration. And so I'm just going to jump right into it, okay? Okay. Someone says, can you pin the numbers? Okay, let me just, I'm gonna just type in the office number. It's very hard for me to type and talk at the same time, so hopefully you guys can see this pin. That's the number right there. Plug Queen says, would someone be denied a medical visa if they have a U.S. citizen spouse? I mean, it just depends, is your spouse already filing for you? Regular visas, meaning non-immigrant visas, are, really subjective and at the discretion of the USCIS officer that's reviewing your case. It's not like other cases where it's a matter of fact or a matter of law, where if you're married to a U.S. citizen and the U.S. citizen is petitioning for you and there's good faith marriage, that they should, make a decision in the positive. So I can't really answer the question. It just depends on the circumstances in your particular case. Okay. Let's see. I applied for my brother 8 years ago and I haven't received an approval notice. Can you please explain why? Nadia, the reason why you haven't received anything is because it takes anywhere from like 16 to 20 years, depending on what country you're from, for a application for your sibling to go through. So those typically take the longest time, unfortunately. So you're still very much within a normal processing time, okay? Amber on YouTube says, I have a VAL work permit and a travel document since a year now. Can I travel internationally via cruise? I'm also a DACA recipient. I can't answer the question without knowing your personal immigration history. So, I would need to know your personal immigration history to be able to answer it. But as a general, if you, for anyone who, is a VAL applicant and you have a work and travel permit, and you don't have any removal proceedings, you're not, depending on what stage you are, you've just recently submitted your application and gotten this approval, and you've not gone to any interviews or received any RFEs or NOIDs. In those cases, it's generally safe to travel. If you fall in one of those categories, I'm usually very hesitant to say travel because anything could happen. You could travel and a decision is made in your case and they deny your case. So without knowing more about you and your case, I cannot give you any kind of yes or no answer. Okay. And then Christiana is asking, can I go to Canada with advanced parole? Again, guys, remember, advanced parole is not for you to go to another country. Advanced parole is permission to re-enter into the United States or permission to enter into the United States. So the responsibility is on you to find out if the country's passport you have allows you to go to another country. And if it allows you to go to another country and you fall under what I just mentioned earlier, fine. But again, remember, the advanced parole is what allows you to come back into the United States. Okay? All right. I filed for VAWA in May. I got a prima facie in July. What's an estimated time for EADs? If you file an adjustment of status application and an EAD based on the adjustment of status with your VAWA case, typically it can take anywhere from 4 to 9 months for most people to get a work permit. If you didn't file an adjustment of status, but you're requesting an EAD based on your VAWA application, that can take you 2 to 3 years. So it just depends on which one you filed. James Carl says, new here. What is this channel about? Well, welcome, James. This is an immigration channel. We talk about immigration laws and issues in the United States. And, you know, if you have an immigration question, you can certainly ask your question. Okay, let's see. Good morning, Grizzle from South Carolina. Welcome. This is your first time. How long does it take to get an answer back after submitting more evidence for marriage? The answer also depends. It just really depends on the field office, you know. It depends on at what stage did you get your RFE. Was it at the National Benefits Center level? Was it at the field office? Every field office is different. So, you know, I can't really tell you because I don't know what field office you're in, you know, but generally, if you've not heard anything for like 6 months, maybe you can do an inquiry just to see, you know, what's taking a little, you know, what's taking it so long, and hopefully you can get a response. Good morning. I have a question. Is it true you can obtain your citizenship in 4 weeks? I mean, I'm not really sure what context you're asking it, but if you're eligible to file for citizenship, you can file for citizenship. And some people are lucky where once they submit their citizenship application, they may be called for an interview very quickly. I would say maybe the quickest that we've gotten at our firm, maybe like 40 days. So I guess technically, what's that, like 5 weeks, 5.5 weeks. So it is possible, you know, it's just, but that's not the norm. But it is definitely possible. Derek Shipson says, do you work on NIWs? No, I don't. Good morning, Miriam from New York. Good morning, Sammy Poo. Okay, let me scroll down to the questions. Marcella from Boston, good morning. How long after your work permit is sent will they send the green card, or what next? After your work permit is sent, you just basically will wait until they either call you for, well, again, I don't know what kind of case you have, so I'm just answering based on a generic, maybe marriage-based case or, you know, whatever. So typically after you get your work permit, you know, you're usually in a waiting stage. So you can either be called for an interview or you can be called, no, for an interview. You can either be called for an interview or they can request additional evidence, or you could get a notice of intent to deny. So there are many things that could happen, hopefully. Or the final one is, of course, they could bypass the interview and say, you know, your application is complete, and it's more likely than not that you have a genuine marriage and they could approve your green card. So those are the 4 scenarios that can happen. And again, I know you guys ask so much about timelines, but honestly, it's not possible for any lawyer to give you an exact timeline because we don't make the decisions. And if you even talk to an immigration officer, they can't answer the question for another immigration officer. Like decisions are made based on the immigration officer that's reviewing your case, how many people they have on their plate. Are they someone that's fast in processing cases? Are they someone that's slow? Are they someone that needs more evidence or someone that doesn't need more evidence? And that's why they give you guys aspirational timelines. And it's very simple to just go on USCIS case processing time online, and you'll be able to type in the kind of case you have, and it will give you an aspirational timeline. Those aspirational timelines are just basically saying that we hope that 80% of the applicants in this category would have made a decision, but there's still the 20%, which you never really know where you fall, which could mean that you could get your decision earlier or you could get your decision later. But it's just nobody can really pinpoint a timeline. We can just kind of give like estimates of what it could potentially be based on what we've seen. I have a few months to meet the 5-year citizenship application. Will you be able to help? Absolutely. Handle naturalization cases. And typically you can file, 90 days before the 5-year mark. I mean, there are other things that we have to make sure that you're eligible for. I mean, you have a male picture on your profile. So assuming you're a male, I'll just kind of list the things that you need for naturalization. So for naturalization, we want to know if you got your green card within the ages of 18 to 25, right before you turn 26. Did you apply for selective service, or did you register for selective service? Are you paying your taxes? We want to also look at your travel history. You want to make sure that you've been in the United States for at least 2.5 years of that 5-year timeline. You also want to make sure they don't have any crimes of moral turpitude or any criminal records or anything that during the green card process that you didn't disclose that could potentially come up in a naturalization interview that could make them believe that there was some sort of fraud or anything like that. Also, if you have children and your children are not, if the children are not in your custody and they're minors, we want to know how are you supporting them financially. So these are some of the things that they will typically look at to make a decision for naturalization. And then of course you have to do the civics test. Okay. Someone says the number pinned yours. Yes, this is our office number. You can definitely call to schedule a consultation. Can a Mexican citizen make me a Mexican citizen? I'm a U.S. citizen. So we only handle U.S. immigration laws. I don't know anything about Mexican citizenship or how it works. So, you're probably better off speaking with a lawyer in Mexico. Is it true about the executive order that Mr. Biden speaks about? Okay, so let me also address this for those of you who don't know. So, sometime in June, President Biden passed an executive order that's basically called like parole in place. The idea is to keep couples together, families together. And basically what that rule entails is basically saying that, if you had been in the United States and you entered without inspection, meaning you entered without any customs and border allowing you in, and you've been in this country for 10 years, as of June, I want to say it's 15th, 2024. And also, you've been married to a US citizen as of June 15th, 2024. There will be a path for you to get a green card through parole in place. The applications are supposed to start on August 19th, which is essentially next week, Monday. We are still waiting for guidance in this. So I don't really know like what they're planning to do, because I mean, if you're trying to have us start applying for people on August 19th, we should get some instructions as to what they should be applying for. But the one thing that I would say is if you fall in this category, you're definitely going to need to prove that you've been in the country for 10 years. So it's a good idea to start documenting, your existence here in the United States, for the last 10 years, like have something, whether it's school records, medical records, health insurance, car insurance, rent, car note, church, mosque, synagogue membership, like just anything that you can associate for each of the last 10 years. So 10 years would be, at the very minimum, 2014. So that much you need to get, and then also, obviously your marriage certificate. Many people have asked me, well, my spouse is a U.S. citizen, and our case was denied or whatever it is. Why can't I be eligible for this rule? And for those people that have asked me, they came into the country with a B1, B2 visa. The reason why you're not eligible for this rule is because when you come into this country with a permitted visa and you go through customs and border, you are allowed to adjust your status. So there's no need for them to create a new rule because you're already allowed to adjust your status. For people who enter without inspection, they're not allowed to adjust their status normally. The normal route is they have to just do the I-130. Once the I-130 is approved, um, then they have to request, a waiver, a hardship waiver, which is a 601A waiver. If that waiver is approved, they typically have to go back to their home country. So for those people, they cannot adjust. So that's why this rule is being created for them, because they've been in this country for a really long time. Just guys, give me 1 second. My children are harassing me, and they're going to be on timeout when I get out of this live, because they're starting school on Thursday. So I'm currently home with my kids today. And, this is a preview of being a mother and a working, woman. My kids interrupt my lives and I requested screen time. So sorry about that. Okay, let's see. Can a land purchase document my spouse and I bought in my country be the reason I am placed on AP? I took the land docs to my spousal interview. What do you mean placed on AP? I'm not really sure I understand what you mean by that. Sorry. If a minor is 16 years old and has been in therapy for PTSD and abuse, can they apply for citizenship? How long does it take? So a minor cannot apply for naturalization. You're either going to derive naturalization from a parent, or you can apply for naturalization after 18 years old. However, if the minor experienced abuse with a U.S. citizen or green card holder parent, they can apply for a green card, not citizenship, but they can apply for a green card based on that abuse, but they have to have a parent who's a U.S. citizen or a green card holder. Okay, let's see what else we got. I just received my social security and work permit via VAWA. Then I got a notice to do biometrics for permanent residence. Does this mean I'll get my decision soon about my permanent residency? No, I wish. It takes VAWA cases take anywhere from 2 to 3 years. So if you're just getting your social and work permit, most likely you're getting it in year one of your application. So you still have another good year or 2 years, unless you have really extenuating circumstances to request an expedited decision. It is incredibly difficult to get an expedited decision. Like they deny these for things that I personally feel like they shouldn't be denying them for. But your case will continue processing as normal, like everybody else. Okay. Okay. I'm just coming on, so I've missed this question being asked and responded to. But what are the causes for an interview? Not really sure I understand what you mean, but prior to last year, you were required to have an interview if you have a marriage-based case. The cause for an interview is to determine whether they believe you have a good faith marriage or not, or whether you're admissible into the United States. A lot of people right now get bypassed, and then they get caught on the other end, which is for your conditional green card removal of conditions. So every officer is different. Sometimes, we may have someone who there's absolutely no reason for an interview. Like they have, sonograms, they have a childbirth, they have a birth certificate, they have everything else, and you might have an officer still call them for an interview. So there's no method or reasoning, but I can definitely tell you that if you have an immigration history, especially in a history where the previous case was denied, if there's an age difference, if there is, any question as to cohabitation, where you live versus where your spouse lives, and that's not clear. The evidence really seems scanty. You came from one marriage right into the next marriage. These kinds of cases will typically have interviews. Now, having an interview does not mean that your case is not going to be approved. Absolutely not. It just means that sometimes they want to ask questions and get more clarity on the relationship. Okay. I'm on a C1D visa for cruise ship employment. Am I restricted to work only on cruises, or can I also use this visa for inland employment in the United States? You are absolutely restricted from being on that cruise. And as a matter of fact, if you violate your C1D visa, or you choose to stay on land and not go back, you will not be able to adjust your status through marriage. Like, even if you marry a US citizen, you will not be able to adjust your status through marriage unless you're eligible for a vow of self-petition. So those are very restrictive visas. So you want to make sure that you abide by the rules of those visas. I'm an American citizen married to a non-citizen who has been in the United States for 2.5 years. When should we apply for citizenship? Blessed, the first thing that you need to do is you should be applying for a green card for your non-citizen. And you can do that right now. And then after she has had her green card for 3 years, you can then apply for citizenship. Is it unwise to travel for advanced parole while awaiting USCIS decision? It's a spouse-based application. Nana, it really depends. It really depends on what stage you are. If you already had an interview and you're waiting for a decision, yeah, you should absolutely not travel because you want to make sure that that decision is in your favor. And typically, they will issue decisions relatively quickly for most people right after the interview. If you've just put in your application and you got your work and travel permit, no interviews, no RFEs or whatever, and you have no immigration history where you've applied multiple times and you're kind of like a red flag to them about good faith marriage, or you don't have any deportations, in those cases, you should be fine to travel. But again, I don't know your personal case, so I'm just speaking generally, not for you in particular. It's saying that you guys can hear me. Can you guys hear me now? Sorry, guys, I didn't see that. If you guys can hear me on Instagram, but you guys can hear me on Facebook, right? Okay, so you can hear me. Yeah, that was because of what my daughter did. She messed up my live by making a request on my phone. So sorry about that. Should I apply for a fiance visa now or wait till we marry in December for a spouse visa? The answer is really up to you. There are many benefits to a fiance visa. There are many benefits to a spousal visa, which is a green card. My personal preference, me personally, so this is not, this, you can do whatever you want to do, is always a marriage-based case, because when you enter into the United States as a green card holder, you don't have to then apply again for adjustment of status. You don't have to wait to get a work permit or to be able to work and do all those things, and also you don't have to worry, if things don't work out, God forbid, that you're never going to be able to adjust your status and then you're stuck in this country and in limbo. With a fiance visa, yeah, you might be able to come here a couple months, and really only not by a significant amount, a couple of months earlier, but you're still going to have to put an adjustment of status application. And God forbid your spouse decides, you know what, I don't want to be with you anymore, even though I brought you to this country. That's it, for you. You can't marry somebody else and adjust your status, So they're just different reasonings for different things. And, when people come to consultations with me, I try to give them the pros and cons, and timelines of both and allow them to make the decision. But for some people, it's worth it to them for their spouse to be here earlier, And for some people, if it's just a couple more months for them to be done with the whole process, they would rather wait. So it just depends. If your travel parole is approved and issued, would you advise using it before it expires, or would it be okay to travel at least once on it? You don't have to use your travel permit at all. It doesn't make any difference. But if you want to use your travel permit, you want to definitely use it before it expires. And truly, please do not be one of those who waits until the month it's expiring to say you want to use your travel permit. If you want to travel, it's always good to travel well before the expiration date, ideally 6 months before. But there's no requirement that you have to use it, and there's no requirement that you don't need to use it. It's just really up to you. The idea of an advance parole is to give you a backup if you needed to travel. Like sometimes some people don't need to travel, but having that gives them comfort in knowing that if there's an emergency or an urgent reason for them to travel, that they can travel. Chums Williams says, does a notice of intent to deny usually give a person a deadline to submit the documents that's requested? Yes, you usually have anywhere between 30 to 33 days, depending on how the notice of intent to deny was received. So you have a very, very quick deadline, and this deadline is typically quicker than a request for additional evidence. With an RFE request for additional evidence, you typically will have 87 days, but with a notice of intent to deny, you essentially have 1 month. So you have to be very quick. If they don't get your response before the deadline, then they will deny your case. Okay. I received my work permit and travel permit, and then I received my 1-year prima facie. So are you asking me if it's normal? I'm not sure what your question is, but if that's what you're asking me, yes, that's a normal kind of like timeline. Okay, let's see. Ava Oma says, excuse my multiple questions. Just want to see if I don't know if I can see your question. I can. Did I already answer you? Because I can't see the question. Sorry. You guys, this thing goes so fast. Like it's scrolling through as I'm trying to read a question. It's like going up on my end. So like I just go with whatever is there. So I don't know if I answered it already. But if not, schedule a consultation. Our number is PIN 407-995-6567. I'm going to take one more call and then I got to jump off. Can I travel to Nigeria with my 2-year green card? Absolutely. A 2-year green card means that you are a green card holder. So you have the same exact benefits as you would if you had a 10-year green card. Now, the only caveat is hopefully you didn't apply for asylum against Nigeria. So we always want to look at, if you have a green card, you have a travel permit, you definitely don't want to be going to a country that you're claiming asylum, for. So that's what it is. Joe Houston says, you always bring a slide. You're very inspirational. Thank you so much. Really appreciate it. And I always see you leaving very lovely comments on Facebook, and I truly appreciate it. I truly appreciate all of you guys and the lovely comments you guys leave on social media. And even those of you who leave negative comments, we also appreciate your comments as well, All right, guys, I hope you guys have an amazing day, and I will talk to you guys later. Bye.